Hello everyone, and thank you for tuning in to today's webinar. We have a great presentation lined up for you today, but before we get started, there are just a few general admin points to cover. First and foremost, please use the online question tool to post any questions that you have, and we will share them with our speakers. Second, if you experience any technical difficulties today, please use that same questions tool and a member of our admin team will be on hand to support you. And finally, just to note, today's session is being recorded and we'll be sharing a copy with you all via email in the coming days. So, without further ado, it's my pleasure to hand over to our speakers to get us started.
Good morning, good afternoon. This is Dick Kelly. I'm a senior partner at Oblon, which you can tell by my gray hair. And I'm joined by Vince Shire. We're both from the Chemical Practice Group. And Vince, why don't you say a few words about yourself and then we'll get moving.
Hi, my name is Vince Shire. I'm a partner as well in the Chemical Life Sciences Group at Oblon. I've been doing it not so long as Dick, as my hair is not nearly as gray and far better looking. I have a PhD in biological chemistry, and it's a little bit about me. I'll turn it back to Dick and we'll get going.
Okay, what we're going to talk about today is something that is sort of sitting just below the surface on the 101 issue. And that is that the Patent Office guidance is in conflict with the CAF case law and the Supreme Court case law, I might add. And the Federal Circuit has criticized and refused to follow the Patent Office guidance in a number of cases. Now, this places us in a very difficult position as patent procurement people. Our job is to get a patent, and especially in life sciences and in some of the other fields, patents are very valuable. So we need to get not only a patent that will pass muster in the Patent Office, but also one that will pass muster in an enforcement action. And thus far, all of the courts that have looked at the Patent Office guidance have rejected it, refused to follow it. Now, one of the things you might ask is, why is that? Well, the Patent Office does not have what is called substantive rulemaking authority. And substantive rulemaking authority is one where it's entitled to interpret the statutes that it enforces. Now, this concept didn't come into US law until the mid-1930s with the New Deal and Franklin Roosevelt. And when the Congress was enacting things like the SEC regulations, we have it today with the EPA and things, Congress gave the agencies the ability to interpret the statute. Basically, it turned over the common law function of the courts to interpret the statutes to the government agencies. The Patent Office was created in 1830. Back then, that wasn't the case. What they were charged with is enforcing the laws as passed by Congress and interpreted by the courts. And that has not changed to this day. Despite all the amendments to patent laws, they've never been given substantive rulemaking authority. Now, when you're promulgating rules, you have to promulgate under the Administrative Procedures Act. That also covers things like guidance documents. Now, these regulations, if they're promulgated under that, have certain things happen. You get notice in the Federal Register, you get an opportunity for public comment. The agency has the opportunity, you have the opportunity to petition for amendment or withdrawal. And something that I left off the slide is if the agency goes ahead and puts it into place anyway, you have 30 days in which to file suit and challenge that rule before it goes into effect. So this is what the Administrative Procedure Act provides for. Now, what's happened lately is the director, basically the Assistant Secretary for Commerce for Science and Technology, has, under Mr. Anaku, made a habit of avoiding the APA provisions for notice and appeals by using guidance documents and what are called precedential opinions. Those are opinions by the PTAB, which the Patent Office considers to be binding on the examiners and on the PTAB, which means that we have to deal with them as if they're binding on us. Now, by doing this approach, sure.
But with respect to these guidance and precedential opinions that are issued by the director, aren't they by and large just simply a summary and sort of a reflection of what the state of the case law is and how it should be applied?
Well, that's what guidance documents are supposed to do. In this case, the Patent Office, ANACO, actually came out and said he wants to influence how the courts are going. Second, if you get a 101 rejection today, you won't hear anything about Federal Circuit cases. The examiners are copying and pasting right out of the guidance document. Precedential opinions, that is on attack right now in the FinTIV case. That's not a way of creating rules or guidance that's going to affect the future. Now, the Patent Office does have substantive rulemaking authority for amendments in post-grant review, period. Now, when we look at what is a rule, and this is why the 101 guidance falls afoul of this, it means it's something, a statement by the agency that has general or particular applicability, here 101, and future effect, designed to implement, interpret, or prescribe law. And there isn't much doubt that that is the case. And there is Supreme Court, the District of Columbia gets a lot of these rule cases, and in Stewart v. Smith, they explain what all that means. Basically, since the guidance is telling the examiners what they should do when they examine in the future, it falls afoul of this quite clearly. Same with the precedential opinions. Now, what guidance documents can do is declare an understanding of a statute. Now, that's what the case law says in Fertilizer Institute with the EPA. Statute can also include case law that applies the statute to the agency. The agency can't go beyond the text of the statutes and exercise its delegated powers without providing the adequate notice and comment. In other words, proceed by rule. And the guidance document here under 101 is clearly acting as a rule as defined by the APA. Much of the MPP, however, is really okay because it's simply explaining to the examiners what the law is, and trying to help them understand things like the law on 112 and what have you. Now, this is just a summary of what we said. And again, it's future effect plus either implement, interpret, or prescribe law, or describe organization, procedure, or practice. Now, the top one, designed to implement, that's a substantive rule. The bottom one is primarily a procedural rule. The Patent Office has the authority to issue procedural rules. Every agency does. Now, we know this is intended for future activity simply because the director stated so. And at least in one place, this is at the AIPPI in London, I believe last year, he said it's to establish consistency and predictability prescribing the law. And he wanted to influence the courts that set the law the PTO is to follow. Now, that's all the hallmarks of a rule. Now, one of the things I noticed is quite unusual. If you'll read most of the MPEP sections, they don't say anything about whether it's guidance or not. The section on 101 actually begins with a paragraph which says, the guidelines have been promulgated to assist office personnel in review of the applications. They say the guidelines do not alter substantive requirements of 35 USC 101 and 112. So, and they specifically say do not constitute substantive rulemaking and don't have the force and effect of law. Try telling that to an examiner who's rejecting you on the guidance. Try telling you to the PTAB, who is affirming an examiner's rejection under 101 under the guidance. You're probably beating your head against a stone wall. So this is the problem that we have. By doing this, the Patent Office has insulated the process from court review. Now, this is what I've just said. Now, this rule, this guidance, was rejected by the courts, and they rejected it because it was not promulgated as a rule. In a very interesting decision, Judge Brinkham of the Eastern District of Virginia basically told the attorney who was arguing that the Patent Office guidance showed that their claim was eligible, needed to go back to law school and learn about administrative law. In that case, what had happened is Cleveland Clinic had lost a patent to 101, but it had a continuation pending in the Patent Office. And so what it did was copy one of the examples in the Patent Office guidance, example 29, and then argued to the court that since we're following the Patent Office guidance, it's got to be patent eligible. No. And the district court's decision was affirmed by the Federal Circuit. And what they said, what they say here is primarily, we are mindful of the need for consistent application of our case law. The Patent Office's guidance is not a consistent application of their case law. Now, the interesting thing about Cleveland Clinic, they said it was strikingly similar to Ariosa Claim 1. Ariosa is actually the Sequenum case, and which was found to be patent ineligible by the district court, by the Federal Circuit on the first time, on a request for rehearing en banc, and the Supreme Court denied cert. So kind of hard to get around that. And this is a comparison of example 29, PTO guidance, and the claim in Ariosa. And what you're looking at is, you can see it's a method for detecting paternally inherited nucleic acid in Ariosa, a method for detecting Jewel-1, which was a protein, naturally occurring, although newly discovered. The steps involved obtaining a plasma sample from the patient, right, same as in Ariosa, and detecting whether the Jewel-1 was present. The steps in Claim 1 of Ariosa was amplifying and detecting. Same format. One is ineligible. One, according to the Patent Office, is eligible. And this is the conflict that we have. And Cleveland Clinic got caught right in that conflict and lost the patent.
Dick, it's important, I think, to note as well is that when we think of the guidance and we think of the examples, in particular in the life sciences area, what happens is even when the courts are evolving and they're making decisions, like in Cleveland Clinic, and as you've shown us that the claims parallel each other, the Patent Office isn't keeping up to date. And these examples continue to linger in the Patent Office guidance. They're not being taken out or changed to show that the evolving jurisprudence has declared these claims or similar claims ineligible.
Well, some of that is inertia, but I think some of that is the desire of the Patent Office to try and turn the ship around. But you know, it's sort of like they're run into an immovable object in the Federal Circuit, and they're not getting any help from any other court. I'm not surprised that they haven't updated it. This has been a problem of the Patent Office going back before I joined. And I don't see any movement by them to do it because the PTAB continues to use this. Now, Athena is another case involving diagnostics in which the Federal Circuit rather brusquely decided this claim was patent ineligible because it began and ended with the natural law, namely this kinase, which I've abbreviated as MUSK because the full name would take up the whole slide. And if you look at the claim, Athena was the first to recognize that this neurotransmission disorder could be caused by this kinase. Everybody else in the past had thought the sole cause was a cholinesterase. So the problem was, or an antibody to cholinesterase. And so they discovered that there was a new thing to look for to diagnose for it. And when I first read the case, I said, what is wrong with the Federal Circuit? In the Mayo case, the Supreme Court said that the only things were patent ineligible in this sense were things which were not routinely done by people in the field. Here, the diagnosing was not routinely done. You couldn't do it until the MUSK was discovered. And nevertheless, the Federal Circuit found this to be patent ineligible. And again, as Vince just said, there's no movement by the Patent Office to make any changes or modifications. And this is what has come out in a series of cases by the Federal Circuit. And while in the Cleveland Clinic case, they were kind of mild, here they're coming out and hitting the Patent Office straight. That it's the case law, the Federal Circuit case law, and the Supreme Court precedent that must control.
Do you think there's an argument, though, that could be made that somehow the Federal Circuit itself is not doing itself great favor by providing substantial guidance in their own opinions as to justify or make it clear what is eligible, what isn't eligible?
I think you've hit on something, which we'll talk about in a little bit later when we look at these cases in detail. The problem that you have is that the Federal Circuit has never been noted for its legal scholarship. And in the area of patent eligibility, their decisions do not explain well why the claims are patent ineligible. If you go back and you actually read the patent in the Athena case, you'll understand that what was invented is not what was claimed. Also, that what was claimed is not enabled for its full scope. And when you run into that, you can run into patent ineligibility. One of the things to remember is in patent litigation, the defendant wants to end the case quickly. It's expensive. And second, he wants to avoid a trial. This means he wants to avoid a trial and he wants to avoid discovery. 101 is a totally legal defense and can be decided by the court without a trial, without even summary judgment, by bringing a 12b6 motion to dismiss the complaint as not having a legal basis. In other words, if everything's true in the complaint, you still don't have a legal cause because the claims are patent ineligible. And that's what makes 101 such a powerful tool for patent infringers. Now, basically, as patent practitioners, we're kind of caught between Scylla and Charybdis, and no matter which way you turn, you're in trouble. First off, if you follow the guidance verbatim, and that's what you rely on totally, you're risking, as they did in Cleveland Clinic, an invalid patent. Now, if you ignore the guidance, on the other hand, if you ignore the guidance and try to tell the patent examiner that he's wrong, he can't use the guidance, you're probably going to have an extended prosecution. So you're sort of caught between following the guidance, risking an invalid patent, or ignoring the guidance and having a difficult time of it. Now, one of the things that, while I'm talking about the guidance not being binding, this is unfortunate because a tremendous amount of the guidance actually is good. It sets forth the procedure by which you make a lot of the decisions. And so you should cite it where appropriate, use the tools at office where appropriate, but also cite the case law that shows it's consistent with the guidance. So that when a court looks at this later, they're going to see that the arguments were not simply that the guidance was mandated allowance, but that the case law did as well. An example of a pretty good summary of what the examiner should do is actually found in this little flow chart they drew. Now, this is a good summary of the law. Nothing wrong with it, although the Federal Circuit basically says you can't look at any of this because this is Patent Office guidance and it's not our law. Much of it is based on Federal Circuit decisions. Where you have the problem and where the Patent Office gets into trouble is when you're answering the questions of steps 1, 2A, and 2B. And in particular, what they've done is they've given the examiners examples of things that are patent eligible and are not patent eligible. Now, some of them are taken straight from the case law and those are good, but some are not. They're made up by the Patent Office. And that's where the trouble begins. That's where Cleveland Clinic got into trouble. This is what I just said. Now, example 29 is an example that's wrong. The Federal Circuit has said it's wrong. But it's not the only thing that's wrong. If you go through the guidance, they've got some examples that are wrong in identifying an example as patent ineligible. Example 28 is one of those, vaccines. There, the Patent Office claims that a claim to a peptide separated from a virus, which can be a vaccine against the virus, which is claimed as a vaccine comprising peptide F, the peptide from the virus, and a pharmaceutically acceptable carrier, is patent ineligible. Now, if you read, they have the next one they say is claim 4. They say a vaccine comprising peptide F and a pharmaceutically acceptable carrier selected from the group consisting of, and there's creams, emulsions, gels, liposomes, nanoparticles, or ointments. Now, what's the difference between claims 3 and 4? Well, all that they did in claim 4 is add what they meant by pharmaceutically acceptable carrier. When they said claim 3 is ineligible, they then said claim 4 is eligible based on the plain meaning of vaccines and pharmaceutically acceptable carrier. And how you interpret it as the broadest reasonable interpretation is a sufficient amount of peptide F to produce an immunogenic response in a typical patient, which is mixed with a sufficient amount of other substances to produce a carrier suitable for administration to a patient. Under that, how is claim 3 not patent eligible? So you got to be careful with these examples. And you got to be careful when the examiner pulls them out, make sure that they in fact are patent ineligible. So what's our recommendation? First off, don't limit your arguments to guidance. Show how you've complied with the case law. You want to make a record where a reviewing court will look with favor on the Patent Office decision in deciding a motion to dismiss on the basis of 101. And that's the one thing that the patent owner can do in a motion to dismiss on the 12b6 is the file history of the patent can come in. And if you show that the Patent Office had before it the arguments that it took were those of case law, they are less likely to grant the motion to dismiss. If it's patent, the other thing is to remember, if it's patent eligible under court decisions, then it is patent eligible under the USPTO guidance. The inconsistency is the PTO guidance with the Federal Circuit's decisions on what's ineligible. On eligibility, the court decisions and the USPTO guidance are, in a way, consonant when you're looking at it from that position. It's just that they haven't done it. Now, as far as courts looking at the prosecution history and deciding motions to dismiss, that was done in the Vanda case by Judge Stark out of Delaware, which was affirmed on appeal. And in that case, the Patent Office actually had an extensive discussion of 101, and it did not involve the use of the guidance. And Judge Stark, he did his own analysis, but he also used the Patent Office one to sort of confirm to his mind that he was correct. Oops. So let's look at sequenum, or Ariosa, as the Federal Circuit likes to talk about it. Because when this claim was held patent eligible, it was very, very controversial. And I think it's still controversial to this day. This is claim one in its entirety, and it's got a blank in it for a reason. And basically, claim one was detecting paternally inherited nucleic acid from the fetus by analyzing the maternal serum or plasma, obviously from a pregnant female, by amplifying it, detecting it in the sample. Now, the problem with this claim, which the Federal Circuit did not pick out at all and didn't harp on, is people had been doing these very steps and failing to find the DNA in the sample. And the argument that Sequena made in the District Court, Federal Circuit, and in its opposition to the petition for certiorari was that the invention was in selecting the fraction of the serum or plasma sample to do the amplification on and detection. That's not in the claim. Now, what the Federal Circuit did note that this was the Sequenum's attorneys, litigation attorneys, made a huge mistake. They picked claim one as being representative of all the claims. What the Federal Circuit in passing said, which you first read it, you're not going to pay much attention to it, was, hey, the Sequenum's picked claim one as representative, but we note that claims 24 and 25 are very different. And what you see here in claim 24 is the selection of the fraction which is to be amplified. That was what they argued in all their briefs, was the invention, not seen in claim one. Now, so these are the amendments that are actually the difference between claim 24 and claim one. If you think about the practitioner who did this patent, he wanted to get the broadest possible claim, and he did in claim one. He probably was surprised that that passed muster in the Patent Office. Claim 24 is the invention. Claim 24 is patent eligible. although it wasn't presented to the court, because it has a step in there which allows you to actually successfully perform the amplification. And that's a key point. Now, what was not argued to the Federal Circuit or the district court, in all fairness, they did not try to interpret the claim as requiring selecting the specific fraction at issue. They wanted to get a broad claim. And as a result, they got no claim. In fact, the Ariosa diagnostic test infringes Claim 24. We know that from subsequent case. Now, how do I know that Claim 24 is patent eligible? Well, in a follow-on case involving the same technology but an improvement, the claim was pretty much the same as Claim 1 here. Had pretty much the same preamble, which is a functional description of the invention, no means of achieving the objective, but they had the means of conducting the separation of fractioning the sample so that you got the right fraction to do your amplification of using size exclusion. So, and Ariosa and the district court, having already been through the Ariosa case the first time, said, oh yeah, that's patent ineligible, and I went quick, got to the Federal Circuit, and the Federal Circuit said no. What they're doing is they're using a natural law, size exclusion, to achieve a specific result. So when you look at things, one thing you can look at when you're deciding whether a claim is patent eligible or not, ask yourself, has that claim enabled for the full scope of the claim? If it's not, you could face a 12b6 motion in litigation. They're going to say, well, why don't they use enabling disclosure? Well, because that can't be decided on a 12b6 motion. The 101 can be, because there's no facts that you have to look at in 101. There are facts in an enabling disclosure. So that's why it gets picked on. Now, this is just a summary of what I just said. And it's a warning to everybody, really, if you're going to pick a representative claim, don't pick just one, pick a couple. It's important. I had a appeal before the PTAB where I thought all our claims were patent eligible, but I singled a couple out because they had some limitations that were really different. And the PTAB didn't agree with me on the broadest claim, but they agreed with me on the narrower claims. And it turns out that the narrower claims are just as good as the broad claims, because anybody who's going to use the technique is going to infringe them. And so when it came back from the PTAB with those two claims noted as not being unpatentable, I amended the independent claim and got an immediate allowance. Now, this is the summary of what I've said. You can look at it. One of the things that is important is understanding that discovering the source of a problem can make an obvious solution patentable. And that's a Supreme Court decision, IVO processing, that goes back into the 1920s, which involved the use of gravity to solve a problem, which was obvious once the source of the problem had been identified. So if you look at Sequentum, what they did is they identified the reason why people weren't finding the DNA. They were looking in the wrong fraction. Obvious, once you know that.
Can you comment on the Illumina case?
Yeah, in Illumina, as I said, I did a little bit. They actually, let me go back. Here, this step was a size exclusion looking at the cell populations and excluding certain cell sizes, and that actually improved the diagnostic procedure. So they had a step which was new and which allowed this amplification to proceed better. So they weren't claiming the DNA that you got from the amplification. They were claiming a process which included this unique step.
Size exclusion in general is a known technique. So how does it fit in with the scheme of the unconventional steps?
Well, the test is, and the Federal Circuit has never been terribly clear on it, and maybe not even consistent. But if you go back to Mayo, it has to be something that is well known and practiced in the field of the invention of the claim. So the fact that size exclusion had been used as a method of separating various cell populations from one another, while that's old, no one had used it in this type of analytical technique, this diagnostic procedure. And that's why it's considered to be a patentable addition. And it was interesting that that was the case. People hadn't realized that you could do that and get an improved result in this particular area. Now, the Athena case, as I said, when this case first came down, I said, how is this not patent eligible? It was not conventional or routine in the art of diagnosing for neurotransmission or developmental disorders by detecting the presence or absence of antibodies to this kinase. That wasn't done. That was brand spanking new. And in order to figure out what was going on, it was necessary for me to go into the patent itself and see what the patentee was talking about. Now, first off, this technique that's in Claim 1 doesn't work in the majority of cases. This would return a negative result in 80% of the cases where the neurotransmission disorder was present. So what they're really doing here is trying to claim, they're really trying to preempt people from using MuSK. And that's really one test. Is there a preemption going on? Is somebody who wants to use MuSK necessarily going to infringe this claim? The answer is probably yes. Because remember, the claim preamble is not a limitation in most cases. So what you have is a claim that is too broad from what the description and the specification is, and which also can be read as being preemption. Now, in the Ariosa case, the district court spent most of its time talking about preemption. That's what bothered the district court the most about that claim, because if someone wanted to look at the maternal sample for the fetal DNA, they had to do what was in Claim 1, and that's preemption. And so you got to be careful about that. When you add the other limitation, it's no longer preemption. Now you're doing something different. Now, if you look at this, it says diagnosing, detecting, pretty much the same thing as sample 29 for the Patent Office, which was specifically said not to be correct by the Federal Circuit. Now, one of the problems with the Federal Circuit is when it talks about whether steps are conventional or not, they typically discuss about them in the abstract, divorced from the claims. Here they said the claim began and ended with natural law, steps must be new, found the steps not new. Now, what Mayo says is the claim process in that case, apart from the natural laws themselves, involve all well understood, routine, and conventional activity previously engaged in by researchers in the field. Well, sure as a heck in Athena, researchers weren't doing it in the field, routinely or any other way. However, if you go back into the patent, what you'll find that the problem the patentee was trying to solve was detecting this neurodegenerative disease, which I'm going to call MG, where the patient had tested negative for an antibody against acetylcholine receptor. It was one of the problems with this test for acetylcholine receptors, the antibody, is that in about 20% of the cases, you got a negative result, but MG was present. And how the doctor wound up determining that was as the condition kept getting worse and worse. So while early detection of any disease is important, the acetylcholine receptor test didn't work in all the cases. So what really was the invention, and this comes right out of the early columns, was you take a sample from a subject who exhibits the symptoms of MG, and it tested negative for the antibody. Then you look for the MuSK. Then you look at the label that you used, and that's an indicator that the patient has MG. This claim is fully enabled for its full scope because you've eliminated all of the patients who are going to give a false negative, those that have the acetylcholine, an antibody to the acetylcholine receptor. In the MuSK test, they give a negative. So this claim, number one, it tracks what the inventor did. Number two, it prevents you from saying that the detecting the presence of MuSK is preempted, because you're only going to do that if the patient has turned up with a negative antibody test. And this is what should have been done by the patentee in that case. And the court should have done a better job of explaining why it was saying this was routine or conventional. And they didn't. You know, had they explained that this was what the man described as invention, and he described that 80% of the cases that have the MG have the antibody against acetylcholine and not the MuSK, you would have understood why the court came out where it did. It's the failure of the Federal Circuit to really explain things well that gets us into a lot of trouble. If you go back and you look at most of the Federal Circuit decisions, which scratch your head over, if you actually get into the patent itself, which, believe me, no examiner ever does, and most of us attorneys don't do it, you realize that it wasn't such a bad decision after all. American Axle is an example in the mechanical arts, where the Patent Office allowed the case and the Federal Circuit said no, and the District Court said no, this is a natural law case. And the reason it was a natural law case is that there was nothing in the claim which set forth a specific structure which utilized Hooke's law. Nor, when you go into the patent itself, was there a single structure described which would perform the damping of the vibrations and drive shafts. And that was a whole invention. They were trying to use Hooke's law, where you had different sections. We had an insert that had different sections with different vibration damping characteristics. The problem was that they didn't explain where those sections were, how they were arranged, or anything. And that leaves you with what they call a non-enabling disclosure, but it's also an abstract idea. I want to stop damping in the drive shaft, so I'm going to use Hooke's law. Well, wonderful. How do I apply it? What is the structure that I get, or structures? And it's really the failure of the patent drafter to do a good job on the claims. So I want to give some general practice tips. First, the Patent Office guidance is useful, but it's not the law. So while you can use it with the examiner, remember you got to bring the law in. Second, you've got to look at your claims, not from the point of view of what the USPTO guidance says, but what the Federal Circuit's law is. Don't be lulled into a false sense of security if you pick one of the examples in the guidance, especially one which the Patent Office made up, because it may very well be wrong. And that's where the guidance gets into real trouble. You want to look at your claims for the question of, are you preempting the use of the natural law? In other words, are you preventing someone from designing around your invention? If you're preempting the use of a natural law, it is patent ineligible. The other thing you want to do, you want to make sure your claim is enabled for its full scope. If not, it's going to fall into the abstract idea bucket, which you could put American Axle as well, patent ineligible. This concept of having an enabling disclosure to avoid an abstract idea is an old one. It goes back to Justice Story in 1840. So what we're talking about here is not something that's new. Federal Circuit didn't come up with it. It's been the law of the land for, I guess, 160 years. Now, when you're talking about things like biomarkers, the biomarker detection in a claim should be one limitation. But the claim itself, and especially the preamble, should be not direct the detection of the biomarker per se, but the presence of the disease. Now, the exception to this is if the analytical procedure you're using is brand new, then that may be a different story. But if you're talking about biomarkers in general, you're using standard techniques to detect them. So you want to make sure that your claim is directed to the detection of disease and not to the biomarker. And you can see, if you remove the biomarker limitation from the claim, is the claim still new? And by that, I mean you remove the first instance. And if it's still new, then you probably are okay. And the other thing is you want to make sure that your claim has full enabling disclosure. Source of the problem solved. That's something that's a way of making sure that you make it. Idle processing means by which the problem was solved. You've got to provide not just the source of the problem, but how you solve the problem. If you're not doing the second part, you've got a problem as well. Now, the Alice two-step process everybody talks about, remember, steps can be routine and conventional, but not in the specific field. And that's Berkheimer. And in Berkheimer, they found that the steps, yeah, they were pretty conventional. The problem was they weren't conventional in the field. Now, there's a couple of Patent Office decisions, PTAB decisions, that apply this. One is ex parte Lee, which is non-precedential, but is a diagnostic procedure where they said all the steps were routine, but no one had ever put them together the way the applicant did. In a computer implemented case, ex parte Henham, they did the same thing. Now, ex parte Lee is not precedential, it's not informative, so basically it can be ignored by the patent examiners. But Henham is considered to be an informative decision. In other words, it's giving guidance to people as to how you should do the examination. So those are two things that you can use. In the case I talked about where I got the board to reverse on 2 claims, I used ex parte Lee and Hannon as support. And, you know, the thing that you got to do is you got to make sure you're claiming the use of the natural law. Too often we get lazy and don't do that. In a lot of cases, you may want to consider patient or subject selection claims, which is the Vanda case. If you're in litigation, avoid as much as you can the use of representative claims. Second, make sure that you pick claims that are representative, which are going to match up with your claim construction. And that was where Sequenum went down. The litigation attorneys did a poor, poor job. And I know we got some questions. Try to define, you know, when you go to draft a claim, one of the things people do, they start drafting the claim immediately. I was guilty of that. And when I joined Oblon after having 5 years experience as an examiner, I figured I know how to write a claim. And so first case I was working on, Norman asked me to report it to him, and he said, "What's the invention, Dick?" And so I proceeded to spew out a claim. And he stopped me and he said, "No, I want to know what the inventor is the first to do, 5 to 10 words. Actually, Norman told me 5 words, but he couldn't count really well. So you could get away with 10. And then what you do, what he says, look, now tell me how the invention's to be performed. When you do that, you're going to find that you're almost inevitably going to write a claim, if you follow that format, that is going to be patent eligible. It's also a good way for distinguishing over prior art. And an example of that, in Sequenum, the invention was the isolation of fetal DNA from the mother's blood serum. How'd they do it? They fraction the blood serum and pick the anucleated part. The mistake, claim 1. Now I see we got some questions.
Yeah. Yeah. So one of the questions that we received was asking how the USPTO is reacting to case law, which appears to contradict the 2019 patent eligibility guidance. Unfortunately, this is where, as we mentioned earlier, the Patent Office has kind of fallen asleep. Prior to 2019, the Patent Office was pretty active, mostly in 2014 through 2016, in trying to work through the evolution of their guidance to respond to how we were seeing some of the early cases of Mayo and Myriad and even through Alice. And the Patent Office was establishing sort of the working guidelines and the guidance that they came out with in 2019. But they were also putting together this list of their fictitious examples. Once 2019 came along, and in fact, in October 2019, when the guidance was published, that was really when the Patent Office quit providing public any updates on the 101 examples or guidelines or anything else. It was incorporated into the June 2020 MPEP revision, but that's largely just incorporating what was the working guidance. But the Patent Office has not provided much, if any, additional updates, modifications, examples that address any of the case law that has come out since 2019. So the Patent Office has really kind of fallen asleep and is no longer really, it seems like, addressing. They're kind of frozen in time in 2019 and stuck on their own specific examples, which, as we've pointed out in this discussion, in many cases, they're internally inconsistent and certainly inconsistent with the actual US jurisprudence. And to make it sort of even a worse case, is not only the examiners are the ones focusing on the guidance and the examples in terms of how they go about conducting examination. But the Patent Office established 101 specialists, which I believe fall within the Quality Assurance Office. And these are trained in the guidance, not in the case law. So if you call in a 101 specialist to try to give advice on a particular case, what they're going to follow is the 101 guidance, the guidance that and the examples that have been sort of stagnant for the last 2 years. And that's, in fact, that's what, as Dick mentioned earlier, it's what the PTAB's following now as well. So we're sort of compiling the problem and not evolving with the case law.
Yeah, the problem is that the way the Patent Office has done it, it's almost impossible to get this question before the Federal Circuit in a manner in which it's going to actually strike down the guidance. If you're a patent applicant and the Patent Office relies on the guidance to allow your claims, well, you're happy, but you don't have a cause of action to appeal if the Patent Office did it for the wrong reasons, because you've had success. In the cases of where the Patent Office has used the guidance to find the claims invalid, the Federal Circuit was very critical. But again, they weren't in a position where the issue was the propriety of the guidance per se, such that they could strike it. So the Federal Circuit's hands are pretty well tied. You almost have to have an inter-party case where the guidance is the deciding factor for or against a party. And if you think about that, the only one that can happen in is a PGR process. And there, the likelihood is that the party who would be complaining would be the petitioner, because the Patent Office applied the guidance and rejected his 101 argument. The problem is that the Patent Office is most likely going to do that at the institution stage, and you won't get, you can't appeal that. You can try to mandamus it, and you might get it. So this is something that's going to sit there for a while, and I just don't know how it gets resolved. I think practitioners have to do a better job of drafting their claims, is the big thing. And also, when they analyze a Federal Circuit case, you almost have to go back to the patent to see what it is the Federal Circuit was having problems with. And that's the only question I see that we need to answer. So I'd like to thank you for your attention. Actually, that should have Vince's name on it as well. If you have any questions that you come up with later, you can email either Vince or myself, and we're happy to answer them at that time.
My contact information is on the front page.
Yeah. This is one, if you notice the copyright date, this slide's a little old.
All right, thank you both for an excellent presentation. I'm sure our audience members will have learned a lot from today's session. Just a quick reminder to those of you still on the line, today's session has been recorded and we will be sharing a copy with you all via email in the coming days. And you'll also have a copy of the slides to refer to as well, and our presenters' contact details should you want to reach out and extend the conversation. But all that's left to say is a huge thank you once again to our speakers, and we wish you all a very pleasant rest of the day.
Thank you.
Thank you.